Case 54, PNCEF versus South Aviation. We find ourselves in the District Courts of Appeal of Florida's 4th District. Facts. The appellant lender moved for a prejudgment writ of replevin pursuant to Section 78 of the Florida statutes to recover 4 aircraft which the borrower's lessee maintained in Broward County. The Circuit Court denied the motion. The lender initially filed an action to recover the aircraft from the borrowers in Illinois, where the borrowers were based. In response, the borrowers alleged that they had leased the aircraft to appellee South Aviation, which maintained the aircraft in Broward County. According to the borrowers, the lessee filed liens against the aircraft and refused to return the aircraft because of the liens. Based on the borrower's response, the lender and the borrowers agreed to submit a proposed order to the Illinois court. The order provided that the lender and the borrowers would establish a joint escrow account, into which the lessee would be required to deposit all sums payable to the borrowers pursuant to the lessee's use of the aircraft. The order further provided, "Nothing contained herein shall constitute a waiver of any right or remedy of the lender to pursue its legal and equitable rights against the borrowers, the lessee, and or the aircraft to the full extent permitted under all applicable agreements and laws." The Illinois court entered the order. The lender then sued the lessee and its owner, Appellee Machado, in Broward County for replevin, conversion, and injunctive relief. The lender's verified complaints: Number 1, described the 4 aircraft by model number, serial number, and registration number, and stated that, to the best knowledge, information, and belief of the lender, the aircraft's value was between $9 million and $11 million, and that the aircraft's location was the Fort Lauderdale-Hollywood International Airport. Number 2, stated that the lender is entitled to possession of the aircraft pursuant to notes and mortgages which the borrowers executed in favor of the lender or its predecessor, copies of which the lender attached to the complaint. 3. Stated that the aircraft are being wrongfully detained by the lessee or its owner, who came into possession thereof by virtue of lease agreements between the borrowers and the lessee, and that the cause of such detention is that the lessee's owner has refused, upon the borrower's request, to return possession of the aircraft to the borrowers. Number 4. Stated that the aircraft have not been taken for a tax assessment or fine pursuant to law. And 5. Stated that the aircraft have not been taken under an execution or attachment against the lender's property. So what's the issue? Whether the lender met its burden of showing that its motion for a prejudgment writ of replevin should have been granted. Holding. The court reversed, concluding that the lender met its burden of showing that its motion for a prejudgment writ of replevin should have been granted. Reasoning. Let's first define some new terms. Replevin is an action for the repossession of personal property wrongfully taken or detained by the defendant, whereby the plaintiff gives security for and holds the property until the court decides who owns it. Also, a writ obtained from a court authorizing the retaking of personal property wrongfully taken or detained. Conversion. The wrongful possession or disposition of another's property as if it were one's own. An act or series of willful interference without lawful justification with any chattel in a manner inconsistent with another's rights, whether that other person is deprived of the use and possession of their chattel. Injunctive relief. A court order commanding or preventing an action. To get an injunction, the complainant must show that there is no plain, adequate, and complete remedy at law, and that an irreparable injury will result unless the relief is granted. The court concluded that the Broward County erred in denying the lender's motion for a prejudgment writ of replevin. They based their conclusion on 3 grounds. Number 1. The lender's verified complaint recited and showed all the information required to obtain an order authorizing the issuance of a prejudgment writ of replevin. Number 2. At the show cause hearing, the lender met its burden of proof. And number 3, the lender satisfied the additional requirements of Section 78 of the Florida statutes. The court reversed and remanded for the Broward Court to enter an order granting the lender's motion for a prejudgment writ of replevin. Based on that order, the Broward Court shall have the power to require the lessee and its owner to locate and return the subject aircraft to Broward County, to proceed with the court's replevin order. If the lessee and its owner do not do so, then the Broward Court may do whatever is necessary, including issuing civil contempt and indirect criminal contempt orders, to compel the lessee and its owner to acquiesce to the court's demands. However, the court may not issue any further orders which directly act on the aircraft until the court confirms that the aircraft are within its in rem or quasi-in rem jurisdictional domain.